Hey, Brian Parker here again. Last videos were on repossession and deficiency judgments. We're going to switch gears here, keeping with the car theme. I get a lot of calls or emails for various things. That repo thing seemed to be so popular that I just went with it, and it's touched a lot of nerves. People are thankful and they're seeking further help, but I got to go into my other audience needs, and a couple of things coming up. One of which I want to do. What I'm going to start doing, and I think it's kind of cool. I measure in my head how many calls I get for certain debt collectors, and one of the most popular is UHG 1 LLC. I have a video in my membership file, but I think what I'm going to start doing now is take actual cases, so it is more meaningful and you can see how I operate, get into the incredible mind of Brian Parker. And so this video is going to be about UHG 1 and an anatomy of a lawsuit against my actual client, and I'm going to tell you how we combat their particular case. By the way, I could do another one tomorrow from another client, different set of facts and different ways that they're breaking the law or kind of not representing things as they claim. You're going to see today exactly what I mean about a old debt buying company that kind of cuts corners and just assumes that you're going to default or the court's going to look the other way, which, by the way, happens. You can show the court exactly how nothing is as they claim it is, and the court goes, yeah, but he owes the debt, which I had that happen. It keeps me up at nights because, having done this probably more than most people, I know what I'm doing. So I'm usually facing a judge and even somebody on the other side that I'm vastly more knowledgeable than. I'm not any better than anybody else. It's just that I know my stuff. And when I look at a case, I can tell you in 2 minutes how it's going to end. And to hear a judge go, hey, yeah, but he owes the debt, which has nothing to do with the ownership of the debt. But I digress. I'm sorry, I'm not giving you money's worth. I'm going to give you an anatomy of an actual UHG 1 case. Who is UHG 1? Very briefly, they are just some debt suing arm, and they go by UHG, UHG 1, UHG 2, yada yada, but it's really a United Holding Group which holds a bunch of debt. And usually when you get your Midland credit or your portfolio recovery, things like that, there are companies like holding companies that hold the debt. It's just a computer. Especially with Midland, it's just a computer. They operate through a debt suing arm, if you will. And in this case, the debt suing arm, in my actual case here, is UHG. I saw a real change when UHG made up something as to who they were, and I figured out that it wasn't who they were. And ever since then, they've changed how they sue lawsuits. So United Holding Group will show up every once in a while. That's not the plaintiff. Here it's represented in this actual case as UHG 1, LLC. What is Parker's #1 rule in fighting debt collection lawsuits, other than the counter affidavit? Hello? It is use their own paperwork against them. And so that's what I've done in this debt buying case. This is a debt buyer who's bought the debt for pennies on the dollar. They usually buy personal online loans or credit cards, stuff like that, like most do. But for some reason, they're one of the companies that always brings the worst debt. And maybe they pay less money, but they seem to, in my experience, bring cases really poorly and badly. They had one good law firm that gave me a hard time. It was the same crap that I was dealing with, but the law firm just really tried to kick my butt. But that got expensive, I think. So now there's another law firm that is not doing such a good job because they don't care. And most don't, because they got thousands of lawsuits and they're just trying to keep the account and they don't take care, as you and I will and do. So I'm going to show you the lawsuit against my client, my answer and defenses, the counterclaim, and again, Parker's rule, what is it? The exhibits will be their own documents that we will use against them. And of course, the all-important counter affidavit will be also discussed. I am going to include with this video everything. The lawsuit, the answer, the defenses, the counterclaim, the exhibits, and the counter affidavit. And I'll include it for you in Word so you can see and move stuff around. Don't use my paperwork the way I use it. I'm not telling you how to practice law, and I never do. I'm not telling you to use those docs. I'm just showing you what I've got. If you can use it as a guide, great. But follow the law of your state. I'm not telling you how to practice in your life or your law or your state. Thank you. Their lawsuit, I'll put up the first page. Shazam. I get a lot of feedback on that Shazam. What that is, it comes from Batman. If you watch the old Batman stuff, whenever they took a punch or something, there'd be this wham or just this really poor technical effect. So it just turns me on. So that's why I do this Shazam. So Shazam, first page. See paragraph 3 and 4 of their lawsuit against my client. And they say, defendant requested an extension of credit from Upgrade, the original creditor, through WebBank, a licensed credit services organization as an installment loan. So a couple of things there. If you look on that first page, paragraph 3, you'll see that what I just said is true. Also, we'll get to this later, they're claiming to be, this is a communication from a debt collector, an attempt to collect a debt, and anything will be used for that purpose. That's your mini Miranda warning. That should not be in a lawsuit. There's a specific statute saying don't do that. But when they do that, as I've counseled in the past, they're protecting themselves one way, but you and I use that against them. So they haven't done a balancing act. They've just said, geez, I gotta protect myself, covering all bases, but we can use that against them. Paragraph 4 says, Upgrade assigned all its rights to UHG 1/22/2020, as evidenced by the bill of sale. Listen to what I just said, because that's going to be the lion's share of how you're going to see how we're going to get them. This is significant. Every debt installment agreement has to have a truth in lending statement, federal law. Those lawsuits are sometimes called TILA lawsuits. And in this case, let me put up the truth in lending disclosure statement, Shazam, and you can see clearly that WebBank is the lender or the original creditor. So they're telling the court or anybody that unfortunately listens that Upgrade is the original creditor. Why do they do that? Think about why they do that. And then they're saying their client their client received the rights from UHG in a bill of sale. So already there's a problem. Then we're going to put the actual contract, the loan contract, up. Shazam. And that is a page that will tell you that the borrowers and the only two parties in this loan agreement are the borrower, which is my client, and WebBank. Upgrade is not listed as a creditor or original creditor. Upgrade is listed as a servicer of the debt, which is not a debt collector, but they also don't own anything. So they would not be the original creditor. Look up the definition of creditor. I don't have to look that up. If someone lends me money, they are the original creditor. There's another term of art called the current creditor. Well, that means someone sold it from the original creditor, but it all starts with the original creditor and the original borrower. So Upgrade did not own anything when the debt originated with WebBank under their own federal TILA, Truth in Lending Statement. They are also claiming that the debt was sold, I think January 20th, 2022 in paragraph 4. January 22nd. That's going to be significant too. So in their paragraph 4 in the complaint, let's just look at it again, paragraph 3 and 4, Shazam of the complaint, you can see where they're claiming that under paragraph 4, Upgrade sold the debt to UHG, the plaintiff, January 22nd, 2020. So let's look at the bill of sale. That most of these debt buying lawsuits, it's like gas in a, here we go with the gas tank reference. It's gas in a car. It's the engine in a car. It's the main propulsion behind lawsuits of collections and debts are and is the bill of sale. The bill of sale is everything to a debt collector or debt buyer. So let's take a look at this bill of sale. Shazam. Now, here's the cool thing. I'm going to read this. The document says, let me read the actual thing. On January 23rd, 2020, each investor reference will sell or cause to be sold, and that's what it says right here, but I'm reading this. A pool of accounts held by such investors and described in the account schedule attached to this bill of sale. So, what are investors? If you're a disciple of mine, it's securitized. The debt was securitized, and a bunch of investors that put the money into the securitization and bond holding process own rights to this. So the bill of sale, while it says Upgrade and UHG 1 have this forward flow agreement. That's every bill of sale references the purchase agreement, which is a forward flow agreement, blah, blah, blah. I'm not going to get into that today, maybe another video. But if you read this, it doesn't actually say that Upgrade sold anything. It literally says it represents and warrants that each of the undersigned investors, unnamed by the way, has executed a limited power of attorney between investor and Upgrade, wherein a designated power is for Upgrading to act as attorney in fact. So what does that mean? They've been named as the attorney in fact to conduct business for the investors that are nameless or not named. This isn't a bill of sale between Upgrade and UHG. It's really easy for someone to go, oh, bill of sale, it says Upgrade, and that'll slide right by most, except Parker with his idiot brain and can't stop reading stuff, and you as a disciple that doesn't have to do that, but is now wary of watching these bill of sales and what they actually say. This doesn't say anything's getting sold between Upgrade, but they're crafty about it. They put in at the top that there is a forward flow agreement. That doesn't say anything was sold. So in fact, they say buy Upgrade as attorney in fact. So nothing by their own documents, remember we used their own documents against it, is showing anything's been sold between Upgrade and UHG. And by the way, this thing's signed on the, or it goes in effect 2020, January 23. Their lawsuit says 22. Why do they do those things? Because they don't give a they don't care. And they know it's just going to slide right through because no one's going to read. Be readers. You can save your butt. Again, let me read. The bill of sale has no language showing the loans or even the loan of the client. My client was sold by Upgrade to UHG. Just that the investors will sell to UHG. That's the way it is. Read it if you want. I'll attach the bill of sale. I'll attach the loan agreement. I'll attach the complaint, the answer, the counterclaim, all that stuff right with the video. Remember I brought out the fact that under paragraph 3, let's put up paragraph 3, first page of the lawsuit, Shazam. See right there, the mini Miranda warning? That's not allowed or required. But they do it to protect themselves on something else. But under 15 U.S.C. E11, it specifically states, and I will read the statute, A debt collector may not, I'll tell you what it is. A debt collector, whenever it makes a contact of a debtor, must tell the debtor that they are debt collectors collecting debt. Anything you say will use that purpose. That's called the mini Miranda warning. It is not considered an initial contact under 1692G that then requires that you put forth the validation warnings and the ability of you to seek your validation response from your letter. If they make a contact to you under 1692G, they must give you your rights, the validation rights, within 5 days of that initial contact. The FDCPA under 1692G says pleadings are not initial contact. So then when they sue you, then a debt collector sues you, they are not required to give you the mini Miranda warning. So that, or your 1692G rights to validate the debt. However, this is violated here because it says right in E11, 1692 E11, this paragraph shall not apply to a formal pleading made in connection with a legal action. So they lose the immunity of having someone say, I got sued, and after 5 days they didn't give me my validation rights under 1692G. Well, the FDCPA protects collection law firms that only sue as opposed to send letters, or if that's their only initiation, they don't have to follow 1692G. However, they included the E11 Miranda warning, which is against the law. So that turns the complaint into initial contact. And the 5 days, I argue, is now kicked off. You better give him, my client, the validation rights, which did not occur. But it's all listed in my counter affidavit. My counter affidavit in this case is a doozy. Let's put it up. It's like probably 2 or 3 pages. I'll put up a couple pages. Shazam. And you can see, and as I've counseled you in the past, see all my videos on killer affidavits and how to do a counter affidavit and following the account stated statute. I won't say the word. Yeah, I will. I call it ASS, the counter affidavit, how to create a killer affidavit. So, ASS, account stated statute. That is your game plan. So you create a full counter affidavit to present your side to show the court how bad job they've done. That'll also attach to your answer. It'll attach to your counterclaim. It'll attach to any motion response. It follows you all the way to trial and your closing argument. The counter affidavit is your opening and closing statement. That's not going to happen here, but I'm trying to tell you how powerful it is. So that information I just told you of how bad a job they did is in the counter affidavit. You can take a look. So that is key to fighting back with these things. And that is the beginning and the end of the anatomy of how to fight UHG 1. They're easy pickings. They just showed you how to beat them. You can beat them with their own documents. Again, my mantra, beat them with their own documents. You don't have to do anything else because the burden of proof is on them. And if they fail that burden of proof, they failed the case and your counter affidavit, your counter claim lives, etc., etc. You'll settle this case. So that's my anatomy of a UHG 1 case, LLC, using an actual case of mine and where we are right now, and I hope it helps your understanding of why they do what they do. Thank you for listening and watching. I offer attorney-client relationship other than just I want to give you information and education and maybe a little entertainment, and do your law and your life the way you do you. Do the voodoo that you do. I'm not telling you how to live your life or your law. Thank you very much for listening.